Hello, everyone, and welcome to Uncivil Law. You may be familiar with the series on Netflix, Making a Murderer, documentary series, and this has been pretty notable, and this is the case it is based on. This is the case that series is based on. So this is the Making a Murderer case. This is Dassey versus Dittman. This is a decision from the United States Court of Appeals en banc from 2017, and it deals with whether a juvenile's confession to very serious crimes was voluntary. In order for a confession to be admitted, it must be knowing, intelligent, and voluntary. This goes to the question of whether or not it was voluntary. Did this juvenile know what he was doing, and did he voluntarily make it? So in today's case, we're going to look at this Making a Murderer situation and see what the Court of Appeals has to say. Let's get started with this. The petitioner, who is the criminal defendant, confessed on videotape to participating in a 2005 prurient assault and violent ending of life of Teresa Halbach and the tearing apart of her body. So super good times. The Wisconsin State Court upheld the conviction for these crimes, finding the confession was voluntary and could be used against him. The principal issue in this habeas corpus appeal in federal court is whether that finding was based on an unreasonable application of Supreme Court precedent or unreasonable view in these facts. Whether the confession was voluntary or not is measured against a general standard that takes into effect the totality of the circumstances. Okay, so we have this person who is under the age of 18, and they are confessing to very serious crimes, and we're confessing to murder, confessing to mutilation, confessing to prurient assault. So about as bad as it gets, all things considered, pretty bad. And so we want to try to figure out whether or not his confession can be used against him. And so the Pennsylvania courts have said yes. And now we're here on a habeas, which is an important postural mechanism. So we are not here on a direct review. We're here on a collateral review. So we've already gone through all the direct reviews. We've already gone through the Pennsylvania system. And the Pennsylvania system has already looked at this question. So now we're not attacking it vertically by appealing it. We're attacking it collaterally. We're coming at it from the side by a habeas petition. We're trying to say, this was an improper thing. And that posture is really important because on a habeas review, the courts have a limited jurisdiction. They have limited role. And they're simply looking for basically a manifest error, manifest mistake, something that was clearly wrong. And so the question is here, is the Court of Appeals able to find that kind of mistake from the Pennsylvania courts, which are otherwise entitled to their judgment? Did the trial court or the Pennsylvania courts make a fundamental mistake in coming to the conclusions that they did? Or is this something that is simply subject to differing people, in which case we have to leave that decision aside? So if it's simply an issue where differing people can come to differing conclusions, the state is the last refuse for that. That's your refuse here. Here are questions only, is there something that no reasonable person could disagree on? All right, so let's do that and figure out if that's true. Some of the factors that would tend to support the finding of this confession was not voluntary. So here's some factors that would say it's not voluntary. His youth, his limited intellectual ability, some of the suggestions by those who were asking him the questions, those people who gave broad assurances to a vulnerable suspect that honesty would produce leniency, and inconsistencies in the confession. So there's some factors that say this wasn't voluntary. Here's some factors that say it was voluntary. Dassey spoke with the interrogators freely. He received and understood Miranda, and his mother also consented. Nice touch. Way to go, Mom. The interrogation took place in a comfortable setting without any physical coercion or intimidation, so there was no physical violence, slamming against the wall or things like that. And without them raised voices, so they weren't shouting and berating him like sometimes do, and it was over a relatively brief period of time. Dassey provided many of the most damning details himself in response to open-ended questions. So he himself was providing the details, and on a number of occasions he resisted his people were questioning him, strong suggestions on particular details, so he's able to show some resistance. And the investigators made no specific promises of leniency, which is very important. So we have some factors here that go one way and some factors go the other way. He was young, he was intellectually challenged or intellectually less smart. The court would go on to say that, he was bordering on lower end of average intelligence. So he was, lower down. And, there were some things that were inconsistent in his testimony and so forth. But he was given Miranda. His mom over here, hero of the tale, consented to Miranda. Way to go, Mom. The police didn't berate him. They didn't physically assault him. He was comfortable. They weren't yelling at him. They made only the most vague kind of things of, this will help you if you confess, which is something the police say like literally all the time. And so therefore, that's factors that go that our way. So how does that balance out? The state court finding that Dassey's confessions were voluntary was not beyond fair debate, and we conclude it is reasonable. So ultimately they lose on that, and now we have to figure out why. First, we have to consider the procedural posture, where this is in terms of the process. So therefore, we have to discuss the standard under the Anti-Terrorism and Effective Death Penalty Act, and then describe the Supreme Court's clearly established law for when a confession is proper. So in considering this habeas corpus petition, our review is governed and greatly limited by the statute. So Congress has, by statute, limited habeas corpus to some pretty core issues. They're trying to limit the ability of these collateral attacks, because again, this isn't an appeal. This is a collateral attack. So these standards are reviewed in 28 U.S.C. 2254, and they're designed to prevent federal habeas retrials and to ensure state convictions are given to the extent possible under law. So one of the things here that the federal government is saying is, one of the things they're saying is, first of all, we don't want retrials. You had a trial, and you've had your appeals, and we don't want you to just come in and just have another trial. Now, it's like we did that. We already did the trial, and we've already had your appeals. So we don't want just this to turn into a retrial. And another thing is, especially in the case of state judgments, states are separate sovereigns. They have the general police power, and they're entitled to respect under our system of government. And so if a state has come to a conclusion under its review, the federal government shouldn't be reversing that unless they can find some real critical mistake. We're not sitting here in judgment of whether we would do the same thing or not. We're trying to figure out whether there's some sort of manifest error. And so that's the whole point of this death penalty, this effective statute, is to make sure that we're giving deference to the trial court and giving deference to the decision below. This statute provides a state court conviction cannot be overturned unless the state court adjudication on a federal claim on the merits resulted in a decision that was contrary to or involved unreasonable application of clearly established federal law as determined by the Supreme Court of the United States, or resulted in a decision that was based on an unreasonable determination of the facts in light of the evidence presented in the state court proceedings. So the trial court went against the federal Supreme Court, or unreasonably applied it, or unreasonably applied the facts. One of those things. The decision the federal courts to look to, what decision does the federal court review? The decision the federal court looks to is the last reasoned state court decision to decide the merit, even if the Supreme Court of the state denied discretionary review, which makes total sense, right? The decision of the federal court that you review is the last time the state spoke, because you're here on a collateral attack. You're entitled to your review through the standard mechanism of appeal. And so the federal court looks at the last person to act in the series. So if that were the trial court, it's the trial court. If it's the Court of Appeals, it's the Court of Appeals. If it's the Supreme Court of the state, it's the Supreme Court of the state. And so that's the judgment we're reviewing, because, that what else would you be doing? Makes sense to me. The standard for legal errors under the statute was meant to be difficult to satisfy. The issue is not whether federal judges agree with a state court decision or even whether the state court decision was correct. The issue is whether it's unreasonably wrong under an objective standard. Separate sovereigns, independent judiciary, all that kind of stuff. So we're not trying to say even if it was correct, we're trying to say if it was manifestly wrong, because otherwise, they should be entitled to their judgment just like we're entitled to our judgment. Makes sense. Put another way, we ask where the state court decision was so lacking in justification there was an error, well understood and comprehended in existing law beyond any possibility for fair-minded disagreement. So again, this is designed to be really, really limited, because again, this is not a direct appeal. The issue isn't on direct appeal, you can ask issues like, did they make a mistake? Was this the wrong decision? But you've had your direct appeal, so you've already rendered those issues. So now we're here on only, did the state government completely screw this? Did they completely fail to understand and give denial of process? We're not here to relitigate, who was right and who was wrong. That's already been done. We're just here to figure out if there was a manifest error. So was there a manifest error? It's designed to be hard. As a result, federal habeas relief from state convictions is relatively rare. It is reserved for those uncommon cases in which a state court veers well outside the channels of reasonable decision-making about federal constitutional claims. The Effective Death Penalty Act deference is not conclusive, however. Where the record shows the state court has strayed from clearly established law, we can and do grant relief. So our deference is deference, not absolute. If you're outside of that, we'll grant you relief. Okay, so now that we've understood the procedural posture of this, where we are procedurally, we have to understand what makes a confession voluntary, what makes it admissible. When can a confession be used against you? What kind of tactics are proper? What kind of tactics are improper? So now we have to discuss the clearly established law as it comes to be established on when confessions can be admitted and when not. So let's do that. Let's figure out what the rules are on confessions. The Due Process Clause of the 14th Amendment forbids the admission of a voluntary commission in the evidence of a criminal proceeding. So if it's involuntary, we can't admit it. So in deciding whether it's voluntary, courts assess the totality of circumstances, both the characteristics relating to the accused and of the interrogation. So we look to both the mechanism of how the interrogation was done and who was being interrogated. The Supreme Court's many cases applying this test have not distilled a doctrine into a comprehensive set of hard rules, though prohibitions on physical coercions are absolute. So this isn't one of those situations where we have, like, if this is true, then this is true. This is more of a floating test. This is more of a looking at the entire picture and trying to figure out what's going on. So short of physical coercion, which is not allowed, we don't allow, we don't allow rubber hoses and that kind of thing. So short of physical coercion, which is absolute, we may look to other things and try to figure out whether or not it was proper. And there are some other absolute rules, by the way. That's not the only example. It's just an example of an absolute rule. But yeah, physical coercion will do it. The general standard has some specific requirements to guide courts. So there are some guidelines. First, a person arguing his confession is involuntary must show the police engaged in a coercive practice, such as physically abusive tactics, which would be coercion per se. Interrogation tactics short of physical force can amount to coercion. So just because you didn't lay hands on them doesn't mean it wasn't coercive. It's possible. The court has condemned tactics designed to exhaust suspects physically and mentally. Such tactics include a long interrogation session or prolonged detention paired with repeated but relatively short questioning. So if the interrogation goes on for a long time, if they keep you in the room forever, it might wear you out. If there's a lot of it, if it's broken up, if there's a lot of it, that might be a problem. And also, incidentally, conduct that shocks the conscience of the court. A good example, incidentally, of that is if the police threaten to take away your children. That's the kind of thing that's been deemed unduly coercive. So you can't threaten people's children like that. So there are certain things that you can't do and certain tactics that are not allowed. The Supreme Court has not found the police tactics not involving physical or mental exhaustion taken alone were sufficient to show involuntariness. In several cases, this court has held officers may deceive suspects through appeals to suspect conscience, by posing as a false friend, and by other means as trickery or bluff. So tactics that are not physically or mentally exhaustive may not show involuntary. So the police are allowed to generally trick you. Such as false promises to a suspect have been similarly not seen as per se coercion, at least if they're not specific. So the police can say things like, this will help you, or people will believe you, or this will assist you in your defense. So they can give very sort of general kind of things of, this will help you if you confess, which, depending on your philosophy, is actually a true statement. The degree to which it will help you is questionable, but if the police say this will help you, presumably it will to some degree. It'll probably also condemn you to a much larger degree, but they can make very general statements. They can't make very specific statements. So if they made some really specific statement, like if you confess, you'll get 5 years less on your sentence. If they made something really specific like that, that might be a problem. And that might be subject to uphold that promise, even if it's admissible. So, but if it's really general and vague, then that's kind of allowed. False promises may be evidence of involuntariness, at least paired with one or more coercive practices, or especially vulnerable defendants as part of a totality. So even if the police don't do something that on its own shocks the conscience, it may be as part of a collection of things, something that goes too far. But generally, the Supreme Court allows police investigators to tell a suspect a cooperative attitude would be beneficial, which, depending on what you mean by beneficial, might be even a true statement, and that's why really, really vague statements are typically allowed. In assessing voluntariness, the courts must weigh tactics and setting of the interrogation alongside any particular vulnerability. So how was it done, and what is the nature of the suspect? Relevant factors as to the suspect include age, intelligence, and education, as well as familiarity with the criminal justice system. The interaction between a suspect's vulnerabilities and police tactics may signal coercion, even in the absence of coercion, physical coercion, and threats. The Supreme Court has made clear that juvenile confessions call for special care in evaluating voluntariness. So the nature of the suspect, including whether the fact they're underage, is a factor in this. And juveniles, pretty much by nature, are less educated, less intelligent, less experienced with the criminal justice system, and so forth and so on. So the Supreme Court has said when it comes to juveniles, you have to be a little bit more, you have to look at it a little bit more cautiously, with a little bit more care, because juveniles might be impressible because of their age, their desire to please authority, and all kinds of stuff. So you have to look at it with a little bit more caution than you would otherwise. All right. As we detailed below, Dassey's case presents a different factor, pointing in opposite directions. The most important to our analysis include his age and intellectual ability, the physical circumstances, and the manner and actions of the police in questioning, including bluffing about what they knew, which is often the police lie, and asserting the value of honesty, which may be a truthful thing depending on your point of view. Honesty is probably good as a value. Also, not murdering people is good as a value, but that's kind of beside the point at this point. Dassey's resistance or receptiveness to suggestions by interrogators and the extent which he provided his most incriminating evidence in the open-ended, non-leading questions is also a factor. Okay, so now that we've gone over these very general guidelines and very general factors that apply, we need to look to what the police did and didn't do as it relates to this particular situation. So let's look at the facts of what the police did and try to figure out what the police did and how they might factor into this equation. So what exactly did the police do? Let's find out. During the early interviews, early in the case, the police investigator spoke with a number of the relatives in early November, including an hour-long interview of a 16-year-old, Brendan Dassey, who lived close by. So when the police were figuring this out initially, one of the people they spoke to was the 16-year-old. Several months later, though, investigators received word that Dassey had been crying uncontrollably and lost about 40 pounds of weight. They proceeded to interview him a total of 3 times on February the 27th, 2016. So the police have come into some information, and maybe we need to do another interview, and so we do 3 interviews on February the 27th. Okay. In these voluntary witness interviews, it became clear that Dassey knew much more about the murder. He signed and initialed a Miranda waiver, and his mother consented, though she did not sit in. Mother of the year over here decided to consent to the Miranda waiver. That's just great. Thanks, Mom. Thanks, Mom, for really looking out for your child's rights over here by signing away the Miranda and then not sitting on the decision, not sitting in on the hearings. That's super good. Way to go. Good work. In those interviews that occurred, Dassey admitted that on October the 31st, he had gone over to Ivory's trailer at about 9 p.m. to help with a bonfire. He told police he had seen parts of human body in the fire. He also said Ivory had threatened to hurt him if he spoke to the police. So initial interview, we had some interview in November. Apparently we learned this guy was crying and lost a bunch of weight. We want to have some more interviews. Mom said yes, super great. And during this interview, we said, I saw body parts in a fire. Sounds like something the police will probably want to follow up on, so let's learn more about the next interrogation. After those interviews, the investigators thought Dassey would be at least a witness to the crime and was struggling with the horror of what he's seen. That would be a good explanation for why he was crying and lost a lot of weight. I was a witness to the crime or the aftermath, and, seeing dead bodies in fires was kind of terrifying. So on March 31st, the investigators obtained his mother's permission for another interview. They then took Dassey from his high school to a local sheriff's department, where he was questioned without the presence of a friendly adult. Mom cannot be bothered to attend. Mom cannot be bothered to hire a lawyer. Mom says, it would be super great. How about if I waive Miranda and my child waives Miranda, and then he goes alone with you to talk in a room by himself? In the car, on the way to the police station, the investigators gave him his standard Miranda warning again. Always a good idea because, the law on this incidentally is a little bit tricky on terms of like how often Miranda has to be given. But if there's a substantial break, the normal rule is you have to give Miranda again. So depending on how long the break is, it depends. This is definitely a long enough break. It's been like weeks or months. It's been a little bit. So the police have to give Miranda again. So he gave him Miranda again. So inform him about his right to remain silent, his right to an attorney, and the possibility statements could be used against him. He then orally acknowledged the warnings and initialed and signed a Miranda waiver. He and the officers then chatted during the ride. The three took a short detour to his home, in which case mom is nowhere to be found, and be like, hey, why are you home early? And, oh, what are you trying to do? Are you trying to go to the police station? Okay. So they took a detour to the home, and they took a pair of bleach-stained jeans, which they kept as evidence. All right. When they arrived at the sheriff's department, Dassey confirmed he understood his rights and still wanted to talk to him. So he's like, you still want to talk to us? Yes. The interview took place in the so-called soft interview room equipped for videotaping. So different interrogation rooms are set up differently. Some are set up a little bit more friendly and some are set up a little bit more, not so friendly. And there's a variety of reasons you might want to interrogate someone in one room or another, right? So some are set up a little bit more casually and some are a little bit more, traditional. Some are a little bit more, the desk with the two chairs and the mirror and the light. And some are a little bit more friendly and set up. And this one is set up for videotaping because why not? Dassey sat on a couch facing the two officers and camera. Over the next 3 hours, Dassey was repeatedly offered food, drinks, restroom breaks, and opportunity to rest. Neither of the investigator tried to prevent him from leaving the room, which he really should have, nor did they try to use any force to compel him to answer questions. Dassey never refused to answer questions, never asked to have counsel or his mother present, and never tried to stop the interview. So far, this is going super, super well for Dassey over here. So far, his mother is like, I see no problem with this, and got Miranda, and his mom's like, that's totally cool. And now he's consenting to searches, and he's going home, and we're getting evidence against him, and he's in the soft interview room, and yeah, it's just going over super duper well. This is, don't talk to the police. Great. Let's press on. So then, during the first hour of questioning, one officer began to tell Dassey how he could help the investigation. Since this information and that information from previous accounts needs a little tightening up, which, depending on exactly what the police were thinking at this statement, might be a completely true statement. So do the police think he's a suspect or a witness? Not clear. So this might be a completely true statement. Like, maybe the police don't think he's a suspect at this point. He's just a witness. And so, we just need some tightening up. So this might be a lie or it just might be the truth. All right, so sensing that Dassey may have held back for whatever reasons, this is a quote, the officer assured Dassey that Mark and I are both in your corner. We're on your side. Acknowledging Dassey's potential concern that talking to the police meant he might get arrested and stuff like that. So Dassey says, if I talk to you, I might get arrested. The investigators say, you should tell the whole truth and don't leave anything out. Talking could be in Dassey's best interest, which, depending again on your frame, could be completely true, even though it might make you look a little bad or make you look like you're more involved than you want to be, because admitting to unfortunate facts would leave no doubt you're the truth. I suppose that's one way of qualifying your best interest. Your best interest is in telling the truth because then people will know you're honest. The first investigator said that from what I'm seeing, even if I filled the holes in the story, I'm thinking you're all right, which again, at this point might be a true statement, depending on what the police exactly think at this point. That might be a completely true statement. So the investigator said, hey, based on what I know, I think you'd be all right, which if they think he's a witness, he might be all right. So this might not even be a lie. And even if it is, it's well within the bounds. I'm thinking you're all right. Okay, you don't have to worry about things. We know what Stephen Avery did. We just need to hear the whole story from you. Which if he's a witness might be plausible, but yeah. The other investigator went next. Honesty here, Brendan, is the thing that's going to help you. Okay, no matter what you did, we can work through that, which is definitely a true statement. No matter what you did, we can definitely work through it. We can work through it by such mechanisms as putting you in jail for the rest of your life, but we can definitely work through it together. We can't make any promises. Good on the police. We can't make any promises because if they're making promises, that might be coercive. So good police strategy. We can't make any promises, but we'll stand behind you no matter what you did, which is so vague as to be, whatever. Okay, because you're being the good guy here, which again might be truthful depending on what the police think. And by your talking to us, it's going to help you, okay? Which again might be truthful depending on what the police say. Because the honest person is one who's going to get the better deal out of everything. These seem like very typical kind of statements from the police. It'd be good for you to be honest. It would be good for you to tell us the truth. We can't make any promises, but it will help. And if you're honest, it might help you get a better deal. After Dassey nodded in agreement, the investigator continued. Honesty is the only thing that will set you free, right? The truth may set you free with God, but not so much with the state, no. And we know, like Tom said, when we reviewed those tapes, we pretty much know everything. That's why we're talking to you again today. This seems like a bluff. The police don't know. There's no tapes. The police don't know. They're bluffing that they know more than they do. Which might be, again, if they think he's a witness, might be just simply a mechanism to tell us what you saw. So even if he's a pure witness, we have it all on tape, but we just didn't confirm that. So, even if they think it doesn't necessarily suggest that they think he's a suspect. They're saying, well, we know everything. Please tell us so we can know more. If the police know everything, why are they interviewing you? As long as you're honest with us, you'll be okay. If you lie, that's going to be a problem. Does that sound fair? Dassey again nodded during the questioning, and so then it turned to the events of October the 31st. So Dassey over here has gotten some very generic, general-sounding police statements of, please tell us what happened. And now he's going to tell them what happened, which is not going to end well for Dassey. Over the course of the next 3 hours, with several breaks in the investigation, Dassey told even a more disturbing and incriminating story about the October 31st. So the police say, please just tell us what happened. He's like, let me tell you about all the things. During the interrogation, the details and sequence of events changed repeatedly. However, as they pressed for more details. So he's giving his story, and the investigators are asking for more information, and his story is being modified. Sequence of events changing, different details changing, which, again, even as a witness, this doesn't necessarily imply thing, because, people might remember things in the wrong order, or as you talk to them more, they might put things differently. So even if he was a pure witness, this wouldn't be completely weird. The portion of the interrogation that provides the most support for the claim that his confession was involuntary and unreliable. All right. For example, because recovered remains of the skull contained trace amounts of leads, the investigator believed that he'd been shot in the head. They are eager for Dassey to describe what else had been done to their head besides cutting and punching. So Dassey over here is giving an event of stories. The investigators believe that she's been shot, and apparently during this, Dassey is only describing cutting and punching. That seems to be what's going on. And the investigators are saying, well, can you tell us more? Can you tell us more? Because they think there was a gun, and he's not mentioning a gun. So they're like, can you give us any more information? So in this exchange, Dassey did not provide the answer they were looking for. So he never says, oh, there was a gun. He offered what seemed like guesses. So maybe he's just guessing because he doesn't know what the police want. So he's like saying, well, was it this or this? Trying to figure out what the police want. So the investigators, being flummoxed by this, abandoned these vague statements and tried something a little bit more direct, which again is perfectly normal police procedure. So they then lost patience, which I don't know really is a fair characterization of it, but that's what the Court of Appeals said. I don't know if it's really a loss of patience or just normal tactics. It's like, you in general, just as a general aside, you'd want to get them to offer it voluntarily because then it's less coercive. You don't want to provide the suggestion. You don't want to have to give them more information than they do. If you as the police officer say in an interrogation, did you kill X? And the person responds back by saying, I didn't shoot them, right? They've given way more information than you asked because how did you know a gun was involved? I didn't mention gun. You mentioned gun. And so if there was a gun involved, you have kind of incriminated yourself by your answer. If I ask if the gun was involved and I ask, did you kill them? And you say, I didn't shoot them, somewhat suggestive that maybe you did because you just provided information I didn't provide you. So this is standard police tactics. So they're going to start with the general and the vague, and they're going to hope that you give them information because they don't want to necessarily do it. But at some point they lost their patience, according to the court anyway, and so they're going to try something more direct. Okay, great. So then they say the following set of statements. All right, I'm just going to come out and ask you, who shot her in the head? Pretty direct. He did. Then why didn't you tell us that? Because I couldn't think of it. Now you remember? He nods yes. Tell us about that then. Dassey continued to do so over the whole course of the interview, revising upward the number of times he was shot from 2 to 3 times and then up to 10 times. So maybe like he's guessing or being inconsistent. Dassey also revised the location of the shooting. First outside the garage, then inside a car, then on the floor of the garage. So he's varying where that's happening. After this shifting exchange about the shooting, the first hour of the interview concluded with Dassey explaining how he and Avery put the body into the fire, how they then moved the car, and finally how they cleaned up the stain in the garage before they went home. So we've got a long set of exchanges over this course of this hour with varying stories about who went, when, where, why, where the shot occurred, how many shots occurred, and blah, blah, blah. And then it ends with, oh, by the way, I helped to put the body in the fire. So then the investigators took a break to confer because presumably at this point, if not before, the investigators thought, maybe he's a suspect. So they're going to take a break to talk amongst themselves. It's like, I put the body in the fire. Maybe we're in a different place than we were an hour ago. During this break, Dassey had the opportunity to rest and use a restroom. Before starting up again, Dassey and one of the officers had this exchange, which might indicate Dassey did not understand the gravity of what's going on. Yeah, talking to the police about the murder and stuff, that's kind of a tell unto itself. But so Dassey, before the next hour starts, Dassey says the following set of statements, which might reveal he doesn't really understand what's going on. He says, how long is it going to take? Officer says it It shouldn't take a whole lot longer. Do you think I can get back to school before 1:29? Probably not. Oh, what's at 1:29? Well, I have a project due in 6th hour. Dassey over here may not fully understand the full implication of what's going on. She's like, do you think I can get back to school by 1:29? No. Why? Because I have a project to turn in. Your project to turn in is not exactly the most pressing problem that is currently before you. The fact that the police think that you may now be an accessory to the murder by helping to dispose of the body might be a problem. In the second hour of the questioning, which apparently is going to be a little bit more interesting because the police, if they weren't thinking so already, their opinion of what's going on has probably changed in the last hour. The investigators sought to confirm more details from the first hour. Probably a good idea. They had only limited success. Dassey provided more confusing details about how they were killed and the status of the bonfire. But in the main, Dassey largely confirmed his account from the first hour, especially the details relating to the prurient assault of Teresa. His story regarding what he saw in the fire, the hands, feet, forehead, and part of a torso, also remained mostly consistent. Great. Signaling that the investigators did not overwhelm his will, however, so this is again a factor that suggests maybe he was voluntary. So was he doing it voluntary? Here's a factor that suggests no, or suggests yes, it was voluntary. Dassey repeatedly resisted the suggestion that he and Avery used wires and cables in hanging the person in the garage in order to commit a torture. So the police over here think torture was involved with wires and cables and presumably have some forensics to that evidence, but he's resisting that. It's like, no, that's not a thing we did. Okay. The investigators also tested his suggestibility. So they're going to see if he's suggestible. All right. So they're going to feed him some false information and see if he confirms it, which, might be a reasonable tactic depending on your strategy. It's like, so I'm going to tell you something and see whether or not you confirm it. And if it's true, then if I know it's not true and you confirm it, then I know that you're not the right person, right? So, okay, let's give that a shot. So here's the exchange. The police, did she have any scars, marks, tattoos, stuff like that you can remember? Okay, I don't remember any tattoos. So then the police try the more specific suggestion. Okay, we know that Teresa had a tattoo on her stomach. Do you remember that? Which is a lie. And he says, oh no, do you disagree with me that I said that? No, but I don't know where it was. Okay, so they say, oh, I know a stomach. I saw a tattoo. There was a tattoo on the stomach, which isn't true. And he says, no, I didn't see that. So his suggestibility, he's not suggestible because it's like, he didn't confirm our lie. So then the investigators took another break, powwow some more, during which Dassey ate a sandwich and briefly fell asleep. Where did the sandwich come from exactly? I don't know, but there's a sandwich involved. I don't know if the cops went to Subway or whatever. Subway eat fresh. I don't know. The investigators then returned to the consequences that Dassey was facing. So they want to tell Dassey, here's some problems that you may not be aware of. So the cops say, what do you think is going to happen? What do you think should happen right now? I don't know. The cops, you obviously know that we're police officers, okay? And he nods yes. And because of what you told us, we're going to have to arrest you. Did you kind of figure that was coming? For what you did, we can't let you go right now. The law will not let us. And so we're not going to be able to go home tonight, all right? He says, does my mom know? Should they say, your mom knows? Great. After briefly discussing some logistics, which I don't know what that is, maybe get the toothbrush or whatever, this exchange continued. Did you kind of, after telling us what you told us, kind of figure this was coming? He nods yes. And then he says, is it only for one day or? So he says, is it only for one day that I'm going to be arrested? We don't know at this time, which is a perfectly fair statement. The police don't know how long it's going to be because, well, they don't know what you're going to be convicted of. So we don't know if it's only going to be a day, but probably not. But let me tell you something. You did the right thing. And then he nods yes. By being honest, you can at least sleep right now. And then the cops say your cooperation is going to help us. It's going to work in your favor, which depending on how you interpret that might be true. I can't say what it's going to do or where you're going to end up, but it's going to work in your favor, and we appreciate your cooperation. I bet they do appreciate it. I bet that's a very true statement indeed. Dassey's mother over here, mother of the year over here, who consented to all this and allowed all this to happen, Barb, who's mother of the year, finally enters the story, comes in the room to speak with Brendan about his arrest and confession. Dassey, now with his head buried in his hands, asks his mother what would happen if Avi gave a different version of events, such as I never did nothing. His mother followed up on this point, asking whether Dassey had done anything to Teresa. The mom, did you do anything? Did you, huh? His son, no. What do you mean not really? They got to my head, huh? Say anything. What do you mean by that? What do you mean by that? Dassey was taken into custody after this interview, which he now contends was involuntary and should not have been used as trial. So, yeah, there's a recitation of the facts of all this stuff, and we have to figure out whether or not he acted, whether or not this was a voluntary confession or not. and whether or not the police did bad things or not. So let's go figure out all that adjudication. So there you go. Before his trial for the super duper horrible murder, Dassey moved to suppress his confession as involuntary. After a briefing and hearing, the trial judge stated a finding of fact in an oral ruling. The judge noted his age and observed that he had an IQ level in the lower range of average to borderline not average. So that's presumably an IQ of around 85 if he's using like standard definitions. The judge noted the school record showed Dassey was in regular track classes but had some special education help. The judge also noted Dassey lacked a criminal record, the non-custodial nature of the interviews, as well as the parties stipulated, and the Miranda waiver from both the days. The judge found Dassey knew he could stop answering questions and he could leave the room at any time, and repeatedly indicated his continuing interest in speaking with the police. The judge found that both Dassey and his mother consented to the interviews on March 1st, way to go, Mom. The judge also quoted several of the investigators' admonitions to tell the truth, including, honesty here is the only thing that's going to help you, and honesty is the only thing that will set so free, on which Dassey will rely so heavily now. Very generic statements, and also not specific, and also, depending on your frame, true. So, there's all that. Throughout the interviews, the judge found the investigators had used a normal speaking tone with no raised voices, no hectoring, or no threats. Nothing on the videotape visually depicts Dassey as being agitated, upset, frightened, or intimidated, and displayed no difficulty in understanding the questions asked of him, though at times prodded to be truthful, and no time did he ask to stop the interview or request his mother or lawyer to be present. The admonitions the judge found admitted to nothing more than a reminder that he had a moral duty to tell the truth. The judge also found Dassey was not coerced because interviewers occasionally pretending to know more than they did, which, is a fairly common tactic, as you'd imagine, and it does not interfere with his power to make rational choices. And finally, the judge found that no frank promises of leniency were made, nothing specific, very vague, general, this will help you, this might help you, this will allow you to sleep, very general, not specific. And in fact, he was flatly told that they can't make any promises, which is also helpful. So the police were kind of doing standard interrogation stuff. On the basis of this finding of fact, given the Dassey's relevant personal characteristics and applying the totality of the circumstances, the judge found the admonitions were voluntary statements and denied the motion to suppress. So the trial judge is looking at all this and trying to figure out whether it's voluntary or not. And the trial judge is in the best overall position to understand the facts, at least, because he has the benefit of observing Dassey. He has the benefit of watching him in the courtroom. So even if Dassey never testifies, he has the benefit of watching him as other people are testifying or giving commentary, so, because he's right there. So even if he never testifies, he has the ability to watch his language, watch his body movement, see if he interrupts, all that good stuff. And to the extent he's offering anything, he can comment. So he's in the best position to see the various witnesses who are testifying and see their truthfulness or not. So he's looking at this entire picture, and looking at all the people there before him, and he says, there's some elements that go one way, there's some elements that go another way, but on balance, I think this is a voluntary statement. The March 1st confession was the most incriminating evidence of the trial, which, is pretty typical. Also a good reason not to talk to the police, because confessions usually help. Dassey, they found guilty on all charges, including participation in the sexual assault and the murder and mutilation of the court, and sentenced to life in prison. So murder with aggravated circumstances, that's usually top count murder. It's usually top count murder for states that make these kinds of distinctions. So not all states do, but for states that do, this is aggravated murder. So this is like top of the range. So life in prison is presumably, the right decision there. So then the 3-judge panel of Wisconsin, and I think I said Pennsylvania at some point earlier in this discussion, so sorry about that. A 3-judge panel of Wisconsin's Court of Appeals affirmed Dassey's conviction, finding the confession was voluntary and any effective assistance of counsel was not prejudicial. So a 3-judge panel of the Court of Appeals on direct appeal says, no problem, we're fine here. After summarizing the trial court's finding, the Court of Appeals concluded the following. The court below's findings are not clearly erroneous. These are like questions of fact. He has the ability to see people, so they're not a clear error. Based on these findings, we conclude Dassey did not show coercion. As long as the statements merely encourage honesty and do not promise any specific leniency, telling a defendant that cooperating would be to his benefit is not coercive. And depending on your frame, is true even in these circumstances. What does it mean to be to your benefit? Right? It's such a generic statement. What does it mean for something to be to your benefit? Even in these circumstances where you got life imprisonment, can you make the argument it was at least in part to his benefit? Well, depending on your view of various morality, then maybe So, and, so it seemed, so there's that. Nor is professing to know facts they actually did not have a coercive. So the police, when they say, oh, we have these facts, and it's not true, that's not coercive either. The use of a deceptive tactic, like exaggerating the strength of evidence against a suspect, does not make a confession involuntary, but instead is a factor to be considered. The truth of the confession remains for the jury to determine. So, yeah, there is the issue of fact about whether or not the confession is ultimately true. And so there's a lot of things the defense could presumably argue to make it not true. So all these statements, because the videotape is available, and so you can bring that in. So the defense lawyer is fully able to argue to the jury, and once it's admissible, fully able to argue that's not true. It's like, look at these inconsistencies, look at these things. He's obviously making things up. He's obviously guessing. He can go to the tape and say, look at this. He's obviously guessing, obviously making things up, just trying to please people. He's a child. He's mentally inferior. He's just trying to please an authority and so forth and so on. And so then it becomes a question for the jury to figure out whether or not the confession itself is true. So it might not be true, or it might be true, but that's a question of fact, right? Is the confession true? Juries have a tendency of believing things that come from people's mouth, even if they shouldn't. So the fact the jury found it to be true is not really weird. So the jury, having heard all this evidence, thought, yeah, we thought it's true, beyond a reasonable doubt, and therefore guilty. So, okay, great. So that's what the Court of Appeals decided. That's what the district court decided, no problem. The Wisconsin Supreme Court denied review, which is discretionary in this circumstance. The Wisconsin Supreme Court denied review, so that it exhausts all your direct reviews. So we have no more direct reviews left. We've heard all the direct reviews. And so now our only options left are collateral, such as by a writ of habeas corpus. So let's give that a shot and see if we can get a writ of habeas corpus, because someone below is not strictly speaking the right word, someone in the case made a manifest error under federal law. So let's give that a shot. The state court's decision that Dassey confessed voluntarily was not unreasonable application of the Supreme Court's precedent. The state appellate court drew on a fairly detailed finding of fact, which were not in clear error. A number of relevant factors we recognize tend to support the claims about the confession, Dassey's claims about the confession. He was young. He was alone with the police. Thanks, Mom. He was somewhat limited intellectually. The officer's questioning included general assertions of leniency if he told the truth. And Dassey may have believed they promised more than they did, which also, incidentally, is a problem for adults who have listening problems for some reason. At times, it appeared as though Dassey simply did not grasp the gravity of his confession, which, incidentally, is also a problem for police or adults. After confessing to the rape and murder, he asked officers if he'd be back in school by afternoon in order to turn in a project. Probably not, no. Portions of the questioning also included leading and suggestive questioning, although not in the early stages, which is, again, standard tactics. And throughout the interrogation, Dassey faced follow-up inquiries when the investigations were not satisfied with what he told them, leading him at times to seem to guess. In addition, the confusion and contradictions in the account of the crimes lend support to the view his confession was the product of suggestions and or desire to tell the police what they want to hear, which incidentally might be questions for the jury, because these are issues you could raise to the jury. An defense lawyer might raise to the jury, and presumably did. And so, the jury didn't think so, so maybe that's just a factual question. At the same time, many other factors support the finding that Dassey's confession was indeed voluntary, so there are other factors. Starting with the circumstances. As stipulated by both sides, Dassey was not in custody when he admitted to participating in the crimes during the initial conversation, because, of course, he was not. He went on with the officers voluntarily and with his mother's knowledge and consent. Way to go. He was given Miranda warnings and understood them sufficiently. Their interrogation was conducted during school hours and in a comfortable setting, in this soft interview room, which may have been done for a whole host of reasons, but it was more comfortable than, a barren wall with a dangling light kind of thing. Dassey showed no signs of physical distress. He had access to food, drinks, and restroom. The interrogation was not particularly lengthy, especially with breaks taken every hour. Yeah, 3-hour interrogation is not particularly lengthy, and there were breaks and so forth and so on. Dassey was not subject to physical coercion or any sort of threat. Given the history of coercive interrogation techniques from which modern constitutional standards for confessions emerge, this is important. It is very important. The investigators stayed calm and never raised their voices. As Wisconsin courts found, there was no sign that he was intimidated. Turning to the techniques used in the interrogation, the investigators told Dassey many times they already knew what happened when in fact they did not, which may be for the purposes of elucidating his testimony as a witness rather than as a suspect. But, they were trying to get him to tell more, and this was a fairly common tactic. This deception is a common interview technique. Yes, it is. To our knowledge, it has not led courts, and certainly not the Supreme Court, to find that the answers are involuntary. Also, most of the incriminating details in Dassey's confession were not suggested by the questioning. He volunteered them open-ended. So, there wasn't like the police provided a suggestion and he responded to the suggestion, which would be a problem, right? They asked open-ended questions like, what happened? What'd you do next? They didn't say like, that was when you strangled her, or that was when you chopped up her body. They didn't do that, which they're not supposed to do. They're not supposed to, because the suggestion can be a problem. So they did open-ended things, and he provided most of the material in response to the open-ended questioning. So the police aren't feeding him information that he's just regurgitating. He's getting this knowledge from somewhere, or to the extent he's not guessing, at least. And so, yeah. When Dassey's story did not make sense, seemed incomplete, or seemed to conflict with other evidence, the questioners pressed Dassey with further questioning, trying to resolve the conflicts. These techniques are not coercive. Dassey responded to such questioning by modifying his story on some points, but he stuck to it in others. So the police are asking some things, and he's like rearranging parts of the story, which again, even as a witness, wouldn't be unheard of. But other things, he's like, no, I'm sure this is what's true. And even where the police are like, no, that's not true, and it's like, no, yes, it is, he's resisting. This supports the view that he was not being pushed to provide a false story against his will, which, makes sense. Even for an adult suspect, they might not remember everything in the right order. They might forget details. They might be like, oh, no, this happened, or no, that happened, or, it can be traumatic events. So, like, the fact that it's inconsistent is not itself suggestive. For example, proving that he still had his will about him, Dassey resisted repeated suggestions he participated in the shooting. He denied repeated suggestions that they'd use wires and cables to restrain or harm the person. In one telling instance, the questioners tested Dassey by falsely telling him that he had a tattoo on his stomach and asking him if he's seen it. So trying to see if he'll just merely echo back what we're saying. And he said no. When the questioners pushed harder, he's not willing to say that he knew that they were wrong, but stuck to his recollection. He saw the tattoo. So even when they pushed him, he said, no, I'm not saying you're wrong. I just didn't see it. So then again, referring back to the posture, where we are on this collateral attack, the essential point here is that the totality of the circumstances test gives courts considerable room for judgment in this case, like this, where factors point in both directions. And there are factors in both directions. There are things that go both ways. So this totality of the circumstances, which by its own nature is a little bit amorphous and vague because there are no firm rules, there are reasons to go both ways. So given the many relevant factors and substantial weight supporting a finding that's voluntary, and this is the critical part here, the state's court's decision was not an unreasonable application of the precedent. The custody question was governed by a similar totality of circumstances test. The Supreme Court summarized the array of factors about putting you in custody or not in custody. So ultimately, there's a whole bunch of factors. And how much those factors should matter is a judgment call. It's a judgment call like many different judgment calls. And so, like, could a person look at this and come to a different conclusion? Yes, I think you could. And so, and even the Court of Appeals is saying, yes, you could. You have some factors that suggest yes and some factors that suggest no. This is a totality of circumstances test. And we're all here on a limited review. And also, the trial court is in the best position to observe the witnesses, observe the suspects, hear the testimony, hear the inclination of the vote. The jury is in the best position to hear all that stuff. So the trial court is in the best position to make these decisions because they have more evidence and more than we do than a cold record. And so here it's an issue of deference. And so even if you could go a different decision, the decision below is not manifestly unreasonable. There's facts that go one way, facts that go another way. People of good conscience can disagree, which seems perfectly reasonable to me, and therefore there's not a basis to overturn. Dassey criticizes the Wisconsin appellate court decision for being too terse. It's too short, addressing the confession in just 2 pivotal paragraphs. So the Court of Appeals of Wisconsin dealt with this matter somewhat summarily. The relative brevity of that part of the opinion is not in and of itself a basis for granting relief, which is totally reasonable. Opinions don't have to be long to be good. They just have to say as much as they do. And personally, I like the terser opinions. We have so many opinions that just go on and on and on. I'm like, get to the point sometimes, which is also a criticism levied at me and my channel, a point which I'm self-aware of and trying to get better at, even though I need a lot of help. Given the volume of words that federal courts have devoted to this case, one might assume the totality of circumstances test requires a lengthy recitation of all the factors and presence of the factor. But no, it doesn't. The assumption is incorrect. The Supreme Court itself has issued terse final determinations on voluntariness after recitation of the facts. So you don't have to go through a lengthy, weighty analysis and present like thorough arguments. The Supreme Court itself has said, here's a whole bunch of facts. Here's our conclusion, end of analysis. And so the appellate court, the Wisconsin appellate court, kind of did the same thing. They listed all the facts and just in 2 paragraphs said, I don't think it's enough. Didn't like go beyond reasoning, but you don't need more than that. If you don't need more than that, and you don't hear. The requirement that courts take special care in analyzing a juvenile's confession does not call for habeas relief here. So even though the courts are to be cautious with juveniles, that in and of itself is not enough. Why? The state appellate court met the requirements for analyzing the judicial confession by considering the age, intellectual capacity, and voluntary absence of the mother during investigation. Way to go, Mom. The state court noted that officers read Dassey his Miranda rights, and Dassey later remembered his rights and agreed to talk anyway. Way to go. The court asserted coercion in relation to these vulnerabilities, including his age, intellectual limitations, and high suggestibility. The court did not limit its inquiry to only whether the most abusive interrogation techniques were used. The court examined the tone and volume of the voices, finding the officers used their normal speaking tones with no hectoring, threats, or promises of leniency, though they did prod to be honest and sought to establish rapport, which again is fairly typical. The court even considered Dassey's physical comfort by noting that he sat on the sofa and was offered food, drink, and restroom breaks. So even though we have to give juveniles special attention, the Court of Appeals here is saying, well, the court did consider all that stuff. They explicitly considered all that stuff. They looked at it, they factored it in, they didn't ignore it, they took the care, and our review is very narrow. Our judgment is very narrow. So they did everything they were supposed to do, they factored it in. So even if we would disagree, that's not our role. Our role is only to find a manifest error. They didn't ignore that, they just factored it in, and they said, well, it comes out one way. So even if you say, well, it should have come out a different way, that's not our role. Our role is simply to say if it's manifest error, and that's not what happened here. Dassey also argues he's entitled to relief under the statute on the ground the state court made an unreasonable finding of fact. So he says, the trial court, or the appellate court for that matter, made a false fact. So what is this false fact? Apparently the false fact is the questioners made no false promises of leniency. So he says, they did make me promises of leniency. Not so much, no. Affirming the trial court, which found no frank promises of leniency were made, the Wisconsin Court of Appeals determined the statements merely encouraged it and did not promise leniency. Yeah, these are very vague, general statements. If you confess, they will help you, they will assist you, they will make your life better. It's not, we will give you a 5-year discount, or you only get this penalty or that penalty. No, it's it's very general. Good things could happen to you. If you do this, it might benefit you. You know, it's possible that something will occur. So no frank statements of leniency, no. Dassey's arguments these findings were unreasonable focuses on two things: his intellectual limitations and spots in the record where he claimed investigators indicated he would not be arrested even if he told the truth, and we reject the argument. Yeah, so no. As noted above, the Supreme Court has not treated general assertions of leniency in exchange for cooperation as coercive. Yeah, because it's very general, and it's like, even if you viewed this in contract law, it's so vague as to like, what are you even bargaining for? So it's like, I didn't get the benefit of my bargain. What were you even bargaining for? It's so vague. There's nothing to hold you to, right? It's a loser. It's illusory if we want to put it in contract language. The promise is illusory. It doesn't mean anything. It's so vague as to be pointless. To the extent precedent from other courts might be helpful in understanding these findings, the case signals such general assurances are not legally relevant for determining whether the will was overcome. A policeman is not a fiduciary of the suspect. No, very much no. The police are allowed to play on ignorance, anxieties, fears, and uncertainties. They're just not allowed to magnify those fears, uncertainties, and so forth to the point where rational decision becomes possible. So you can take advantage of anything latent. You just can't antagonize them. You can't lean on them and make them worse. But if a person is naturally one way, you can lean on them. And here, this seems pretty standard run-of-the-mill interrogation. You know, very general stuff, very open-ended questions. Police just making very general statements, very general assertions. I'm not seeing anything that's really beyond the pale. The district court, the panel majority. So now reviewing where we are in the federal system. So just as a brief reminder before we move on to the federal system, because we're on collateral attack, we have a whole bunch of courts involved. So we have the Wisconsin trial court, who said, this is totally fine. Then we have the Wisconsin Court of Appeals, who said, this is totally fine. Then the federal district court and the 3-judge Court of Appeals said, this is not fine. All right. So trial court said fine. Court of Appeals said fine. The district court federal said not fine. The Court of Appeals federal said not fine, but we're here on bonk. And the Court of Appeals is going to say fine. So we had 2 votes. We have 2 courts who said no, and 2.5, depending on your count. 2.5 because the Court of Appeals twice. 2.5 who said no and yes. But yeah, so no. So these other courts that have said this is not okay have viewed this differently, finding the psychological coercion through a form of operant conditioning, where different investigative tactics combined to convince Dassey. The police then agreed to end the interrogation and grant him leniency in exchange for the confession. So the district court said, oh no, this is like he's just been conditioned into it and it wasn't voluntary. However, the Court of Appeals en banc, disagreeing with its own panel, so the panel came out a different way. The Court of Appeals says the state did not view these tactics the same way. These views by the state are not unreasonable. The court saw and read, as we have, exactly what the questioners told and asked Dassey and how he responded. So they viewed all the same evidence. It's not like there's new evidence or something. They viewed all the same thing. The Effective Death Penalty Act leaves room for reasonable disagreements between these various courts. Disagreement on a particular judgment call does not show it founded unreasonably. So, yeah. So again, the posture here is dictating a lot of this. The Effective Death Penalty Act is preventing this becoming from a second trial or a second review. So the courts below didn't make a mistake. They looked at everything they're supposed to look at. They looked at all the factors. They looked at all the evidence, and they factored that in, and they came to a conclusion. And the conclusion the Court of Appeals says is not objectively unreasonable. And at least on the telling of the Court of Appeals reading of it, I'd have to agree it's not objectively unreasonable. I can definitely see why you would come to a different conclusion. I can definitely see how you would look at this and say, well, it's too much. But to say, well, that's the only conclusion you can come to, there does seem to be evidence that goes both ways. And this is a judgment call, whether it was coercive or not. And the trial court is in the best position to figure that out. So the Court of Appeals here is saying, well, look, the state courts looked at everything. It's not like they ignored the Supreme Court. It's not like they ignored federal law. It's not like they didn't factor in that he was a juvenile. They looked at everything. They factored everything. They considered everything. They wrote about everything. They didn't miss anything. They didn't fail to consider something. They looked at everything and came to a judgment call. And that judgment call, in light of the factors here, is reasonable, even if you'd go the other way. So I think that seems like the most correct conclusion to me. So I'm somewhat agreeing with the Court of Appeals, yeah. The concerns expressed by our dissenting colleagues, as well as the panel decision and the district court decision, about these potential coercive effects of police tactics are understandable. The concerns do make sense. The critics of the interrogation see evidence of fabrication through the confession's inconsistencies and lack of solid corroborating evidence. Some of the confession's inconsistencies are startling, particularly the shifting answers on the location of the shooting, whether it was outside the garage, on the garage floor, or in the car, and his failure to recall consistently the order of attacks in the bedroom. The stabbing, hair cutting, and throat slicing, he couldn't remember the order. Also, during the dialogue about the shooting, the investigators prodded Dassey and injected some critical facts in the discussion that corroborated evidence which they already knew. The state courts, however, did not fail to consider these factual inconsistency or alleged lack of corroborating evidence, though it's not clear how they should have approached this question, if at all. The United States Supreme Court precedent on this point is not clear. In Blackburn versus Alabama, the court considered the unreliability of a confession in determining a mentally ill defendant's confession was not voluntary. The very next year, however, the court indicated the reliability of a confession has nothing to do with its voluntariness, and because extrinsic evidence that a confession is true can confound the inquiry when a defendant's will has been overdone. The court later seemed to signal yet a different direction, writing in Colorado versus Conley that when confession is reliable, as distinct from voluntary, it is a matter to be governed by evidentiary laws of the forum and not by a due process clause. So the Supreme Court has written a whole bunch of guidance which is a little bit confusing and unclear. Analysis of this confession's reliability as part of the totality of circumstances may survive the instruction in Conley, but it's not unreasonable to interpret Conley as foreclosing, or at least not requiring, this line of inquiry before trial. So Conley can be read either way too. We cannot fault, therefore, the Wisconsin court for failing to measure the inconsistency in this context because it's not clear what the Supreme Court wants. In addition, the contradictions as to some details do not necessarily undermine the reliability of core details of the thing, which I suppose is true. The concerns about reliability echo the opinions of some scholars who believe that certain tactics tend to produce false confessions, which is probably very true. Some police departments and experts have acknowledged this criticism and have changed interrogation practices in response. We must note, however, that some interrogation tactics used in this case, like repeating challenges to explain details that seem implausible, reflect practices that are advocated by these reformers. These debates over interrogation techniques have not resulted in a controlling Supreme Court precedent condemning the tactics used with Dassey. Absent clear declaration, we may not create a new constitutional restraint on habeas corpus review. So that brings us to the end of the case of Dassey versus Dittman, which I think is an incredibly detailed case and really tries to go to the heart of what this thing is and trying to go to what the review should be. And I think that this decision makes sense. I think there's evidence that goes both ways. I think you could conclude either way. And I think that the trial court is in the best position to figure that out. And certainly the Court of Appeals, because they're the Court of Appeals for the state, is in the best position to figure this out. So the initial trial court, which has the benefit of observing everyone's behavior, even if the defendant doesn't testify, has the benefit of observing his behavior, hearing the testimony, hearing the tone, watching the tape, listening to all that stuff, and really factoring all that in, is in the best position. So is it clear that they made a mistake as to its admissibility because it was voluntary? I don't know. Then as to whether or not it's true or not, that's a jury question. And again, the jury has the benefit of observing all those things, observing the witnesses, observing the tone, observing the tape, and the defense lawyer is in the position to highlight the inconsistencies. He's in the position to show why it might be unreliable, why he might just trying to be pleasing, why this might be not reliable. And the jury's in the position of trying to figure out beyond a reasonable doubt what is true. And the jury apparently concluded this confession was true, because apparently there was really not much else evidence. And on basis of that, which is a jury question of trier of fact, reached the conclusion that they did. So, like, where's your ability to do anything other than the Court of Appeals did? So I think it was a very illuminating case, and that's the end of the discussion of this case. Thank you so much for being part of the Uncivil Law family. If you liked this latest video, please give it a like below and hit the join button. For 99 cents a month, you too can give a recurring membership that helps this channel grow and helps YouTube to recommend this channel to others. We really appreciate your continued financial support and all your love. And until later, my friends, cheers and goodbye.